Hi, this is John Sarno, and welcome to this month's EANJ Case Law Summary. We have a very consequential case decided by the Supreme Court of the United States. And anytime the Supreme Court decides a case, we're all going to be paying attention to it. And the chances are relatively high that it's going to create a new legal rule. Well, while our case today does not necessarily create a new legal rule, because the law in New Jersey has more or less been consistent with some of the federal cases, nevertheless, the case that we'll be discussing today will have a significant impact on how you go about doing supervisory training and containing liability. Now, the case has to do with a supervisor that badgers an employee, but the supervisor is not necessarily the decision maker. So in this case, the employee is being ridiculed for his military service, and he's being teased by his supervisor that the amount of time that he spends on reserve training is a waste of time, and all they do is drink beer and hang around, and it's teasing, basically. But there comes a time, though, where there is performance issues and difficulty, and of course, those of you who tune into these case law summaries know that there's always an underlying tension or conflict, obviously, between the employer and the employee, which may or may not have anything to do with a supervisor's bias. And ultimately, a decision is made to discharge the employee or to take some sort of corrective disciplinary action, and that happens here. Those of you who have attended our seminars know that in order to make out a discrimination case, and in this case it's discrimination because of military service, in order to make out a discrimination case, you have to show that the decision maker, the person who actually made the decision, harbored a bias. Well, in this particular case, there was no evidence that the decision maker harbored a bias, and therefore the claim was dismissed by the U.S. District Court, the trial court. The judgment was then entered in favor of the employer. The case goes up on appeal, and the Court of Appeals agrees that there was no evidence of the decision maker being biased. The only evidence of bias was this ridicule and badgering by a supervisor who was not involved in the decision. Well, the Supreme Court looks at this case and focuses on the role of the supervisor and finds that if the supervisor influences the decision, that is to say, if the supervisor is a motivating factor in the decision and taints the decision maker's point of view by infecting it, if you will, with this prejudice or bias, then that would be evidence of discrimination. In other words, even though the boss, the decision maker, may not be biased, if a supervisor is influencing the decision, and it can be shown that the supervisor is biased, then a cause for discrimination can be brought. So this is a very, very significant decision. It's called the cat's paw doctrine. That's right, the cat's paw doctrine. Now, why is it called the cat's paw doctrine? Well, you're going to have to scroll down and read my commentary. But suffice to say, when you're thinking about training supervisors, even though they may not be the ultimate decision makers, what they say and what they do may influence a decision maker. For example, if discipline is trumped up, or if the performance evaluation is biased, and that goes on to someone else who makes a decision, well, you can see that the chain of custody, if you will, the chain of command has been infected or tainted by that line supervisor's discrimination. That's what this case stands for. A supervisor, even though he's not the decision maker, can motivate a biased, discriminatory decision. This is a very important case. Please scroll down, read the commentary, also find out why this is called the cat's paw doctrine. If you have any questions, as always, don't hesitate. Send us an email, pick up the phone. We'll see you next month. This is John Sarno saying, take care and be well.